Now I am going to dictate a legal passage based on latest Supreme Court judgment at the rate of 120 words per minute. Let's start. The other segment of the relevant aspects of this case pertains to the conduct of the respondent. In this regard, a few noticeable facts and factors against him could be summarized thus. He has been involved in as many as 53 criminal cases and had been convicted in 2 of them. There had been several allegations against him of threatening the investigating officers and public servants from time to time. Even in the present case too, he had allegedly threatened and misbehaved with the police officers and had been charge sheeted for offences under sections 353 and 506 IPC, and on 23/02/2021 he did not appear before the investigating officer even after dismissal of his writ petition by the High Court and was arrested at a faraway place. These facts and factors prima facie give rise to the question as to whether the respondent was entitled to be granted the indulgence of bail. The High Court has taken the view that prima facie the respondent might not have committed the offence he has been charged with in this case, and looking to his past history, there was nothing on record to suggest that he was likely to commit an offence under the NDPS Act while on bail. The High Court has, in the totality of circumstances, taken the view that the respondent was entitled for bail on stringent conditions and has imposed additional conditions as noticed here in before. Although the past history of the respondent and even his conduct in relation to the processes concerning the present case given rise to a few questions, but the strong countervailing factor in the present case is the prima facie indication that he is being sought to be framed by conditions and baseless stories. Another factor noticeable is that the respondent has not been involved in any NDPS Act case or any akin offence in the past. Interestingly, it is noticed from the material placed on record that nothing of any contraband article has been recovered from the respondent or from any place under his exclusive control. This factor further adds on to the doubt as to whether the respondent had at all been indulgent in narcotics or any contraband. That being the position, the view as taken by the High Court cannot be said to be an altogether unacceptable or impossible view of the matter. Moreover, it cannot be said that the respondent was consciously seeking to abscond on 23/02/2021 merely because he was found in the night at Purbo Bardhaman and not at Kolkata. In any case, the aspect relating to tendency to flee has been duly taken care of with the conditions as imposed by the High Court. The other submissions with reference to the decision in the case of Prashanto Kumar Sarkar (Supra) hardly make out a case for interference, particularly looking to the nature of evidence sought to be adduced by the prosecution against the respondent. In this regard, we would hasten to observe that apart from the stringent conditions already imposed by the High Court, it is always open for the prosecution to seek imposition of any further condition or even to seek cancellation of the bail granted to the respondent in case of any fault on this part in due adherence to the conditions already imposed. In view of the above, we find no reason to consider interference in the order passed by the High Court granting bail to the respondent with specific conditions. Para. Before concluding on the matter, we deem it appropriate to observe that none of the comments herein would be of any bearing on the final view to be taken by the trial court after the trial, because the observations herein are only of prima facie view, and that too so far relevant for the purpose of the question of grant of bail to the respondent. Para. Accordingly, and in view of the above, this appeal fails and is dismissed subject to the observations foregoing. Stop. Thank you.